Every time I read the facts in this case, part of me wants to laugh. It honestly reads like a Monty Python sketch, but the situation would have been anything but amusing for Eileen Sayers. She had arrived at a bus station with her husband, intending to board a bus in 20 minutes. She needed to use the toilet, so she went to the public toilets, placed a penny in the slot, entered the bathroom, and the door closed behind her. She then realised the handle inside the door had broken and she was not able to leave the toilet cubicle. If she waited, presumably her husband would come and get her, but they would also miss the bus. She decided to try to climb over the door and climbed up using the toilet itself and a pipe, but found it would be impossible to get over the door. On her way down, she put her weight on the toilet roll holder, which rolled and caused her to fall and injure herself. She sued the council that operated the toilets. The Master of the Rolls, Lord Evershead, found that the council's negligence was the cause of her injuries and appeared quite sympathetic towards her, but concluded, "I think it would not be right to say that the plaintiff was herself free from blame. I think that in getting to the position where she could see, and did see, that escape via the top of the door was impossible, she acted without carelessness. But I think, though it is of course one of those matters when, no doubt, it is being wise after the event, that in getting back to terra firma again, she should have appreciated that she could not properly and ought not to allow her balance to depend on anything so unstable as a toilet roll and a fixture of a somewhat slender kind. It was not a grave error, and I think the consequences were unduly unfortunate in the circumstances, but I think it is impossible to acquit the plaintiff altogether from some carelessness." The council remained liable, but her damages were reduced by 1/4 to reflect her contribution to the harm. This case stands as an authoritative example of the doctrine of contributory negligence. When a plaintiff contributes to their own harm, their entitlement to damages may be reduced to reflect that contribution.